All right, welcome back. I just realized you're getting a very close-up view of my face, which you won't get another opportunity to get this semester. So you're all the better for it. There are two additional sections in our discussion of consideration, and these have to do with compromises. We'll see that that's a pretty odd concept to define, and also one that really harkens back to all the issues that we discussed earlier in the course. And then the following one is on charitable subscriptions, which again is not really a different thing, right? We'll see that the doctrine of consideration as it usually applies, namely to nullify things that are done unilaterally, will also apply to most donations that meet that definition. So first, compromises that has to do with basically uncertainty as to something. So that's the way in which it harkens back to what we said earlier, and then that uncertainty is being solved by a new agreement. So by something that essentially builds upon an existing agreement, changes it in some way, and provides a benefit to the parties. The first case you have is the Cook v. Wright case, again, very old case, 1861 from England. And you have so we'll see that most of these cases have to do with people being sued, by the way. So first you have, some work being done in a house. That house ostensibly belonged to the person that is being sued, but it turns out it doesn't, and therefore they never had to pay for the work that they are being asked to pay for. But the people who did the work, call them up and they basically say, we're going to sue you like we've sued everybody else. And then the guy thinks that he doesn't really have to pay, right? And therefore could contest that claim if they were to bring that lawsuit, but nonetheless decides to pay it to avoid being sued. Now, the issue, of course, is whether that would be economic duress under the principles we saw earlier, right? Did they use that threat of being sued illegitimately for the purposes of creating pressure on him to do something that he has no obligation to do? And we'll see that that would invalidate the contract under the general principle of duress, which we'll see much later on in the course. Generally, when someone talks about a lawsuit, it is a legitimate uncertainty pursuant to the tests that we saw. So the removal of that uncertainty is sufficient consideration, unless it's completely unfounded as a lawsuit. But here there's uncertainty, right? It turns out they would have lost, but that's not immediately clear. Unless it is that decision that's based upon, his avoidance of being sued constitutes sufficient consideration, and it's also not simply duress. So claims, are by definition more or less meritorious. Some of them are likely to prevail, some of them are very unlikely to prevail, but as long as they were not clearly bound to fail, and that was clear from the onset, that will constitute sufficient consideration. Okay, so that's the discussion of the mistake, Again, if he was mistaken as to whether or not he owned the houses, again harkens back to, whether it was clear or not that that claim would not be meritorious. Okay, unless, again, they call it no ground of defense, but basically if the claim was clearly bound to fail to start with, which, as you'll see from these two cases, is very, from this case, is very, very unusual. Second case is Fairgrave v. Ellis, 1935, so somewhat more recent case. Basically, you have an agreement that the facts are very complicated and don't really matter all that much, but essentially the guy hires a maid. That's the end result of all of that, right? He hires a maid. He doesn't live with his wife because his wife is angry at him and she lives in California. Well, then the wife comes back, and then turns out, right, the maid can't continue to do her job because the wife complains and gets him to essentially try to fire the wife. Tries to get him, to fire sorry, that was very unclear. Tries to get him to fire the maid. The wife tries to get him to fire the maid. And he signs a contract with the maid that says we will rescind our existing contract in exchange for $1,000. Is that subsequent contract valid? And there's a discussion of whether the underlying contract is valid, the statute of frauds, all that. Not important at all. But basically the answer is yes, because there's mutual consideration, right? So she had a right to sue under the contract. Again, right, if it turns out to be an invalid contract, it's always possible. It just means her claim will not be meritorious. Her lawsuit will turn out to fail. But that's not clear from the onset, and she has a right to bring that lawsuit. She does not do that. She gets $1,000 in exchange. That contract is valid. It has consideration. It is mutual, pursuant to the principles that we saw, and therefore it can be enforced by the courts. Second and last section is on charitable subscriptions. As I said, there's really no reasons why that should be a separate section, because it only applies all of the concepts that we saw so far in this course having to do with consideration. And that is that a donation, by default, will be invalid at law because it lacks consideration. If you're giving someone money, right, they might agree to it. They might sign a piece of paper that goes to, again, offering acceptance, but there's no consideration. They're getting something for free. They're not providing anything in exchange of benefit, whether it's money or something else, and therefore that's invalid for a lack of consideration. And you see that applied in these cases. So in that case, right, the guy signs a contract that says he'll donate money to Dalhousie University. Well, by default, that is not a contract. It can be enforced, where the courts can force him to pay the money that he agreed to pay to the university because it's a gratuitous promise, because he did not get anything in exchange. And you're mentioned in quite a bit of detail with the instantiation of a different situation would be if there were a benefit, right? And that's not, again, an exception that we call charity, right, or charitable donations. It's simply an application of the general principles that we saw. If he gets a benefit in exchange, it doesn't make the donation enforceable. It does as a result, but that's because the donation is no longer a gratuitous promise. Instead, it's a mutual promise supported by consideration. And again, because the court will not look at the adequacy of consideration, there does not need to be mutuality or matching of the value of what's being provided for. So if he gets his name on a building, that turns the donation into a mutual promise that is enforceable because there's consideration, right? So he gives money, what he gets in return is his name on a building. And it doesn't matter, again, because the court does not assess the adequacy of consideration. It does not matter that name, that having your name on a building is clearly not worth however much money he's paying for it. So by default, it's not enforceable. You're mentioned in a number of provinces. There are statutes that make these enforceable. So that would turn that category into something else, right? Generally in the maritime provinces, by the way. But that turned that promise that otherwise is not enforceable into something else, into an enforceable contract. And to the extent that you have these statutes, right, then the statutes would prevail. So, because the statute, as we said a number of times in this course, always prevails. The government gets to change the common law, gets to change the rules that were developed by judges by passing a statute, by passing a law. So the government says we enforce contracts for charitable donations without consideration. It's fully entitled to do that. The statute will prevail. So the courts will now not have to require consideration for that kind of contract. We saw that in a different way, right, under when the statute would provide for additional requirements. So one of the examples that we discussed, we didn't see it in a case, but I mentioned it, has to do with real estate contracts. So you have a requirement. It's what we call the statute of frauds rate, but actually they adopted the same rule under statutes that have slightly more modern names today, right? But basically requires a piece of writing that is signed by the party to be charged. So by the party you're trying to enforce a contract against, which usually will mean both, right? Have to sign a piece of paper. That's what statute of fraud says. That can apply in the context of real estate contracts. So we said a contract by default does not have a form. You can have an oral contract as long as you have met the requirements of offer, acceptance, and consideration. Well, the government can say if it's a real estate contract, if it's a contract for the sale of land or buildings, it has got to be in writing. And then the statute will prevail. The law will provide for an additional requirement, and now on top of offer, acceptance, and consideration, you will have to have something that is done in writing. Okay, so that's it for our discussion of offer, acceptance, and consideration. We're done with all of that. Following section, which you'll see is pretty short, about 10 pages, has to do with contractual intention. And that is not necessarily a separate requirement. The way in which you want to conceptualize that is your own and somewhat subjective, because it harkens back to some of the things that we discussed earlier. So we said the offer and the acceptance have to match. That's a way of saying both parties have to have an intention to enter into a contract that is shared. If they don't intend their offer to be a binding offer, which means an offer that is valid in law, that will be enforced by a court if the subsequent contract is not respected, and if the acceptance does not meet these same criteria, is not meant to accept an offer and therefore create a contract that will be coercively enforced by the courts, after that, if it's not being respected, right, you don't have meeting of the minds or whatever you want to call it, a matching offer and acceptance, and therefore you do not have a contract. You can set that out, you can state that as a separate requirement. You can say that the parties have to intend to enter into binding legal relationships. But we basically saw the exact same requirement under the existing principles that we saw throughout the course so far. As you'll see, there's a number of issues, right? If it's a joke, if it's not meant to be taken seriously, again, would just mean that, for example, the offer, the acceptance is not meant to be an offer and therefore does not count. But the main thing, the main context in which you see that is the context of family relations. So when you have people who have a family, which will mean a family or a conjugal relationship, so spousal relationship, the contract will generally not be enforced, and that's imputed to intention. So it's stating that as a general rule, and we'll see it's not meant to be applied all the time, right? You can have exceptions. In other words, you can have binding conjugal or family contracts. By default, though, the parties do not intend for these relationships to create binding contracts. So they might agree, but they don't intend to be sued. And consideration provided a similar policy, had a similar policy underpinning, you'll recall. If people make a donation, we said, they don't intend to get sued on it, right? They might, the counterparty might fully expect them to do it. It might be wrong or bad if they don't. And they might have some other form of, right, social consequence or whatever. But they don't expect to be sued. They don't expect that to be coercively enforced in the way that a mutual promise is. That was one of the underlying policy reasons for the doctrine of consideration. Well, something similar here, right? The parties in family or spousal relationships generally do not intend for their agreements, although they might otherwise meet all of the steps that we saw, right? It depends on whether you construe that as separate or not, as I said earlier. But there's an offer, it's accept, there's consideration, there's a mutual benefit. They still don't intend these promises to be coercively enforced through the court system. You have two examples of that. The first one is the Balfour case from 1919, again, right, from England. Basically, there's an agreement for a husband to provide an allowance to the wife. You're told that that's because she was starting to have health issues, essentially, and whether that constitutes a valid contract. Well, there's an offer, there's an acceptance, there's ostensibly consideration if the wife is providing something in return. But nonetheless, the court says what I said earlier, that the parties do not intend these relationships, these agreements, even if they meet the other criteria, to be legally binding and legally enforceable agreements. Again, that's supposed to reflect the legitimate expectations of the parties, as we saw in a number of contexts, right? Contract law creates requirements that sometimes are weird, sometimes get dated like consideration. But these requirements are supposed to reflect what the parties would expect. And here, the parties generally would not expect to get sued on a promise that's made between a husband and a wife. Another way to state that is that you don't want people to be suing each other, period, right? So they're in a relationship, things go well. Well, you don't want to create an incentive or a tool whereby people will start to coercively enforce contracts or coercively try to enforce contracts when they otherwise would not have. And in fact, right, if they can't, they won't, right? And that causes a detriment to the relationship. In other words, right, people suing each other is not good for spousal relationships, and therefore we don't want that to happen. Then you have the Simpkins case at page 282. Very weird, somewhat unclear, but the principle that comes out of it is that default rule is not an absolute one, like just about everything in the law. So just because people are in a spousal or family relationship will not mean that any contract will be necessarily unenforceable. There's a presumption that it's likely to be unenforceable, but that presumption can be reversed. Does not always apply. Sometimes it will be enforceable. If you have, right, something that's similar to what you'd see in a non-spousal or family context generally, so meets the other, right, business rationales for contract law. So there's a transactional relationship between members of a family that are not closely related, for example, that would be the kind of thing that would be enforceable. Okay. Then you have the Merritt v. Merritt case, 1970, which provides for an exception to that, and basically says that when things are not going well between the spouses, the presumption will not apply. So it refines that principle we just discussed, right? By default, it's not enforceable because people don't intend or expect it to be enforceable. And on top of that, we don't want people to be suing each other. Well, that case, which is Lord Denning, I won't repeat my comments on that, but always good to watch out for when you see that name. When things are not going well between the spouses or the family members. In other words, when things are likely to go wrong, when they would sue each other anyway, the presumption does not apply. their contracts are not presumptively unenforceable. You have an example of that, right? The guy starts cheating on his wife, and then he leaves the spousal home to go live with said woman out of that house. And then they have disagreement, and then they agree that he will pay her some amount of money, out of which she will pay the mortgage. Eventually she pays down the mortgage, and then he essentially reneges on the promise. He says, I won't give you the house. And they actually signed a piece of paper. Again, piece of paper, not sufficient if there's no intention. If the family thing means that the piece of paper by default will not be something people expect to be enforced or enforceable through the court system. But in that case, again, because things were not going well, because the relationship, right, he says the parties were, quote unquote, not living together in amity, it is not by default unenforceable. So their contract will be enforceable, again, if you meet the criteria that we saw for acceptance and consideration. In most provinces, and you have an example of Ontario's statute at page 284, the law provides for additional form requirements. So these are agreements that would be otherwise actually enforceable because of what Lord Denning says. So for example, a separation agreement. That has to be in writing. And again, same thing as what we said for real estate contracts and other situations where the statute of frauds or something similar will apply. The statute prevails. So if the statute says it has to be in writing, and it also says, as you'll see, signed by the parties and witness, well, these requirements apply. So now the common law requirements of offer, acceptance, and consideration are no longer sufficient. You also have to meet on top of that the statutory requirements for the contract to be valid. And that's where we'll stop. I'm at page 284, and that will leave about 14 or so pages for Wednesday, which we should be able to get through even with the more limited time that we have. And of course, the first thing we'll do on Wednesday is answer all the questions you might have on what I talked at you about for just under an hour.